So we'll talk about just 3 cases for sake of time today, but I'm happy to talk with more offline if you want on other cases and examples, or even if you may have gone through, let's call it a hypothetical event that you may have gone through. I'm happy to talk to you about them. But the first one I'm going to talk about is vendors coming on site. And I know that we have some higher ed and universities representation here. So this first one you'll relate to very quickly. And we're not going to talk about your network. We're going to talk about social engineering. We're talking about impersonations. And this was a university client of mine. Guess what? This university had a job fair for college seniors. I'm sure you do the same. Guess what they didn't do? They didn't vet out the employers coming into the job fair. So what happened? 2 criminals impersonated a company, saw an empty table, laid out a tablecloth with blank job applications. 500 seniors in one day applied to them. Guess who walked off with 500 identities in one day? Think about who's coming on your premise. This is one example. I'll tell you right now, the UPS guy and the FedEx guy at the Beazley office in New York City is grateful that I'm on the road 75% of the time. Because when I'm in the office and I see them leaving with a big box and 6 big boxes on the cart, they're like, oh, here he comes again. Every single time I ask them for their ID, I call FedEx or UPS and verify they're still employed with them. I do that every time. It only takes one time that's not the UPS guy, because getting those uniforms are easy. And those 6 big boxes can represent a lot of data that my employer can have. Imagine that being a breach. That happens. So think about who's on your premise. There was a hospital client of ours this summer doing some construction. And guess what? A criminal came in, had a hard hat, had some blueprints, said to the security guard, I'm here to change the light bulbs. So in my position, I'd be like, hard hat, blueprint, what do you need this for changing bulbs? But the security guard, yeah, sure, go right on in. What do? In 15 minutes, they wound up going into physicians' offices and stealing 4 laptops. So again, think about who's on your premise and who can potentially leave with information. You want to be mindful of that, because this is how these events occur. And so, yeah, so what happened from that was paper records. As you can imagine, the job application, I'm sure, did not follow the state employment law in that state. I'm sure they asked for more things than you could possibly imagine, and seniors wanting a job, they just filled them out. This was another client of mine. Financial services, think high net worth, private banking, private client type arrangements. They had 280,000 investor clients. They contacted me when in my previous job from before Beazley, and they advised us saying, Alex, we have malware. We found malware on 5 servers. We want to get letters out the door right now to all of our clients. You don't understand, every client is important, I get it, but these are high net worth clients. They're all very nervous. And we're like, wait, we have to investigate. Just because you found the malware doesn't mean anything. Oh, we're really nervous because we don't want the media to find out. This could be really bad for us. Thankfully, they allowed us to do the investigation before they sent letters out the door. Because what we did is we went back and says, okay, well, we know where the malware is. We have the malware. So let's figure out what it was programmed to do. Let's reverse engineer it, as it's called. Well, when we did that, we found out that it was only programmed, for whatever reason, to only look for credit cards that began with the number 3. If you're in the banking world, those are Amex cards. So Amex cards begin with 3, I think Discover is 6, and Visa is 4, and what have you. So everyone's going to pull out their wallet now and look at their cards. So at the end of the day, we says, okay, well, now that we know what it was programmed to do, we don't necessarily know if data got exfiltrated or not, but at least we know this is all it was looking for. So we went back and said, how many of your 280,000 clients do you have credit cards on file, and of those cards, which ones are Amex? Well, we went back and only about 30,000 were. So imagine the first game plan, plan A. They're about to send a letter to 280,000, equating to 100% of their bread and butter. And they were going to send a notice to say, we don't know what information was compromised. We're very sorry. Here's credit monitoring. If you have any issues, please let us know. I mean, think about that kind of a strategy. And now after the investigation, plan B is we're going to send it to only 12% of our bread and butter. And now we can definitively say in the notice, only your Amex was compromised. Your social security number is safe. Your bank account information is safe. We're very sorry. Just get a new Amex card. If there's any charges you're responsible for, we're happy to cover them for you. Imagine the reputational impact that plan A versus plan B can bring. You have to think of that kind of risk that can raise itself if you don't handle the response correctly and the investigation correctly. And then everybody always asks me, I've handled about 250 breaches in my days. Everyone always asks me, Alex, what's the one that takes the cake? What's the one that causes you to shake your head to this day? And it would be this one. This is a hospital. So imagine post 9/11, they wanted to do a disaster drill of mass casualties. So now they says, well, you know what? We want to add an interesting element to the drill. What happens if the network dies when we're getting all of these patients coming in last minute? In their infinite wisdom, they decided, why don't we replicate as if the network goes down? Let's create a crash cart for each of the 20 emergency room suites. Let's put a laptop on each of the crash carts, and we'll download all 500,000 records of the hospital on the laptops. What a great idea. So they go through the drill. At the end of the drill, they come to realize that only 18 of the 20 emergency room suites were used as part of the drill. So when they went back to retrieve the laptops, guess what? One of the 2 unused suites, the laptop was missing. So at first, they says, we're good because we have encryption here. We encrypt all our laptops. Great. Well, guess what happened? The IT folks had to come into the room, head down and not looking too happy, and said, you know what? This was a temporary assignment, right? Temporary drill. This wasn't permanent. We didn't encrypt the laptops. Do you know how much time it would take to put encryption on 20 laptops, let alone download 500,000 records on 20 laptops? We didn't have time to do that. So now the board is panicked because they're like, so you're telling us there's an unencrypted laptop with all records of the hospital out there? We're holding a press conference. And of course, in my mentality, I'm like, no, stop. We're not. We have to investigate. They went against our advice. They held a press conference. They told the world they lost this laptop. And so we continued our investigation. And it only took us 48 hours. We went through surveillance cameras of the ER, as all ERs have, and we found when the laptop, in fact, was stolen. And in fact, it was stolen. But oddly enough, the assumption, remember what I told you about when you assume, they assumed that it was stolen during the chaos of the drill. It was stolen the night before. So we had the timestamp on the surveillance video. So we went back to the network logs when the IT folks were preparing these laptops. And oddly enough, 19 of the 20 laptops through the network logs showed that the download occurred successfully. But for some reason, one of them didn't. When we did the timestamp comparisons, the laptop was stolen before the download ever occurred on the laptop. So the laptop that was stolen had 0 records on it. There was nothing there. So guess who held a second press conference? They had to tell the world, false alarm, our bad, we made a mistake, nothing got lost. Guess what? Reputational-wise, public didn't buy it. They thought it was a cover-up. They thought that they were lying, and honestly, they didn't lose a single record. So for about 18 months, hindsight is 20/20, we come to find out that their ER visits went down. And coincidentally, the hospital a couple miles down the road saw ER visits go up. So they got a hit reputationally for this, for something that never happened. This was a non-event, as we call it. Those are the mistakes. That's the liability I try to instruct my clients about. Don't just think about the risk of the breach, the event itself, because as the saying goes, you can't unring the bell, you can't cry over spilt milk. So whatever liability comes from the event, we'll deal with it as best as possible. Let's not raise your liability by creating hiccups or hitting some speed bumps as you're going through the investigation phase. That's where the crux of the liability is today. So with that, just the final thoughts I'll leave you on the best practices end. Yes, we're at an insurance conference. Here's my one shameful plug, so I apologize. You need to think about risk transfer here. Why? Because you can put in those controls, the right practices, the right policies, the right talent of employees. But at the end of the day, there's always that residual risk. Things happen by mistake, those oops moments. You want to be able to try and risk transfer that. And not just risk transfer the suits, but imagine the costs when we looked at the methodology. Imagine the costs of the privacy attorney, of the forensics, of generating 100,000 letters, 100,000 credit monitoring codes, a call center. Those are a lot of cost points, and not one blessed suit has come in yet. So you want to risk transfer that as well if you could, and yes, you can do that. Background screening, not just employees. I'll go back to the vendors. Like I said, UPS and FedEx don't like me. But you got to think about that. That's the kind of mentality, unfortunately, in this day and age we are in. You have to have your employees be aware as well. You want to hopefully empower your employees not to feel like they're going to be sanctioned or reprimanded or disciplined by doing something like that. I would do it every day. I would hate to see Beazley have a breach because of something like that. So you have to think about vendor vetting, credentialing, and who's on your premise. In my previous life, when I used to manage breaches, I always used to use a cliche with my clients. I used to say, and forgive me for being a little morbid this morning, I always told clients, you got to prearrange the funeral. You know, you think about that event in the future that nobody wants to talk about or deal with. But you know what? If you put your ducks in a row and your plan in place today and your resources lined up, when that event that nobody wants to deal with happens, it's going to be a lot better to deal with the plan in place today. You don't want to, because as Murphy's Law says, breaches happen Friday night at 10 p.m. And I cannot kid you, when I used to handle breaches, we used to call it Breach Fridays. Fridays are the days breaches get reported in. It's just the phenomenon that occurs. You don't want to have your team assembled Friday night at 10 p.m. saying, what do we do now? What attorney do we pull in? What forensics firm? What is our game plan? You want to have that all up front ahead of time. I talk about e-learning. One thing you can do, in my opinion, that's quite simple, that will help you if, heaven forbid, a regulator is now investigating you, is having proper training of privacy awareness with your workforce. If you don't do that today, that should be your number one initiative when you get back. Regulators coming in to investigate, when they don't see you have privacy awareness training, you are setting such a terrible taste in their mouth for the rest of the investigation. Because what they do is they'll say to you, shame on you for not training your employee how to protect the data in the first place. So if you don't have those kinds of training initiatives, you want to start considering them. And many organizations leverage e-learning. So many of you may have LMS systems, as they're called, learning management systems, e-learning training modules for maybe other things like OSHA regulatory training or employment practices training or anti-corruption training. I know that's in our world, the insurance world. You need to think about using those platforms to offer e-learning courses to workforce about privacy awareness. Demonstrating that is really, really good for a regulator. It just sets the right tone, if you will, for the rest of the investigation. We talk about an incident response plan. That's that written data breach response plan. It not only makes sense, in some states, in some jurisdictions, it's required by law. So you have to, if you're a HIPAA high-tech entity, as we talked earlier, if you're a FTC red flags rule entity, as we talked about earlier, and I think 20 states, I don't think Alabama's one of them, some states have information security laws outside of notice laws that mandate you have a written data breach response plan. And regulators do not want that plan to be an extension of your business continuity plan or disaster recovery plan. They actually will scrutinize to say, no, it's got to be a separate, distinct plan. So keep that in mind. And then with that plan, we want to test it. So you want to do a fire drill at least once a year, and they're formally called tabletop exercises. So once a year, assemble your data breach response team and bring out the plan and see if the plan works today with a fictitious scenario, a breach, and see if it works. Now, some of you are saying, well, Alex, you talk about a data breach response team. Well, what's that? If we have a breach, it's our counsel's issue, right? Or it's our IT folks' issue, right? No, that's another big misconception. A lot of people immediately say, oh, if we have a breach, it's a legal issue or an IT issue. Let them deal with it. A response team can easily be 8 to 10 different stakeholders at your organization. It could be legal, it could be IT, it could be your privacy or compliance folks, it could be your HR office, because what happens if you have a breach of employee data? HR is going to be part of that response team, I can assure you. You have corporate communication folks, I'm sure. You're likely to have your CFO involved, because if it's a significant event, there's a cash flow concern here we have to think about. So physical security, if you have a breaking and entering, the equivalent of physical security in your facility is probably going to be involved. So I just rattled off a good number of stakeholders. You can quickly see a data breach response team is not just 2 folks. It can easily be 6 or 8. And then legislative updates. These laws we're talking about, they're ever changing. By the time I'm done here today, I have to probably go research some new amendment that came out or some new law that's being proposed, because it's that quickly changing. California last week just modified their law. So all of a sudden now I'm focused on what they have now changed in theirs. Florida changed theirs last month. When we talked about 47 state laws, up until July of this year, it was 46 for almost 3 years, until Kentucky joined the bandwagon. So Kentucky now has a law. So lo and behold, these laws are ever evolving. You want to make sure your in-house counsels are kept abreast of all these changes. And then in the midst of an event, I cannot stress the importance enough the importance of that privacy attorney. So privacy counsel is really, really going to be a great advocate, pardon the pun, towards helping you with making sure you stay defensible through that investigation and response. And then notify correctly versus quickly. This is another little cliche I used to use. Don't rush to judgment. Don't jump the gun. Don't do the knee-jerk reaction to get letters out the door tomorrow because you're worried about the media knocking on your door first. If you rush to get letters out the door, you risk potentially prematurely notifying about something that you haven't even investigated. In my humble opinion here, I'll bring back one of the big mega breaches in the news. Target, in my humble opinion, could have handled their event a little differently. If you notice, if you follow the timeline, they kept announcing things, and then 5-6 days later, oh, what we said before, that's not true. Now we find out it's this. And then 5 or 6 days later, they changed their story again. In the public realm, they're losing credibility every time they do that. You don't want to fall into that trap of, well, let's rush and get this message out because we need to make sure we're at least appearing to be doing something. That will always create more liability and reputational harm than if you wait, don't rush to judgment, go through the investigation, build out your facts, and then present that out in your messaging. And as I said, you get one shot to do it. Call center. If you have a breach of 2 people, I don't think any of you are going to need a call center. If you have a breach of 100,000, I think you're going to need a call center. You don't want all these people calling into the main switchboard, and as the stereotype goes, the nice gray-haired old lady answering the phones. You don't want her saying things that might raise your liability. Think about the liability that he or she can raise. Oh my gosh, I can't believe my employer did that to you. They're such fools. I can't believe we're going to fix this for you. No, we don't want that. Guess what else we don't want to have happen? We don't want to have different answers go out the door for the same question that's going to be asked over and over and over again. Nothing gets a regulator more upset than inconsistencies to the same questions being asked. And if you don't think regulators will test to see that you're giving consistent answers, think again. They do that. They will call in, whatever number you publicize, they will call in a few times to make sure that the answers are consistent. If there's inconsistencies, it's like fingernails on a blackboard to them. Then we have to think about the reputational risk advisor. There's that fancy new term I told you earlier. Think about that. Don't just use your typical PR folks. I think I've beaten the investigate horse to death here, so I'm not going to do that anymore. So everyone's got that down. And then the last one. All of you are respectively experts or do your business very well. That's why you're in business. None of you, with all due respect, are breach experts. That's not what you're in the business to do. So why not pull in experts when that type of crisis hits? I'll give you an example. probably to a very strong degree, and thankfully it's not the same type of scenario. Think about kidnap and ransom insurance, called K&R. First off, if any of you have it, don't tell me, because you can't tell me. It's against your policy. But more importantly, I'll bet no one in this room has a full-time hostage negotiator as a full-time employee at your company, because that doesn't happen a lot. And more importantly, you need that expert when that very unfortunate risk happens, because you want a positive outcome from it, right? It's the same thing, but thankfully not to that degree with a breach. A breach is an enterprise crisis matter. You want to pull in people that have dealt with breaches thousands of times before, that know where those pitfalls are, because as I said earlier, the risk is not the event itself, it's how you handle it. So you want that same positive outcome to give you that defensible position.
But when an employee comes in, when they apply for a job or whatever, we pull a credit report,
Yes.
or one of our tenants or something like that, are the applications themselves considered one of those documents as well that we need to be concerned about?
You absolutely do, depending on the data you've collected on that application or in that form. So the mere fact that, again, an applicant or a student or a patient or whoever that individual is, as far as the government's concerned, they're a consumer.
Okay.
And so that consumer has now entrusted you with their data.
So then their ACH, all that stuff too then falls in that same category?
All that is viewed, they're going to be viewed as sensitive information that you've now collected, and that makes you the data owner of that data.
Right.
Different states and different jurisdictions will define which elements on that form you've just collected is deemed sensitive, because not every state is the same as what they define as sensitive. But if that individual resides in a specific state, it's that specific state's law that will define to you which data elements in there is deemed sensitive.
All right, thank you.
Sure.